Yes. Sit by the clipboards. There's a clipboard. Good morning, ladies and gentlemen. I'd like to welcome you to County Court at Law Number 2. My name is Judge Terrence Holmes. I'm the presiding judge here in County Court at Law Number 2. You have been asked to come to court today for what we call an arraignment. And what the arraignment is an opportunity for the court to tell you what you've been charged with, what your rights are, what your options are concerning the case. The case that you have in this court is a criminal case. It is a misdemeanor criminal case. Criminal cases are divided into felonies or misdemeanors. Your felony cases are normally referred to as your more serious type of offenses, whereas your misdemeanor cases are normally referred to as your petty offenses. It does not mean that they're not serious. It just means that they're not as serious as a felony offense. And when I use the term serious, what I'm talking about the facts of the case and the possible punishment that a person can receive if they are convicted of the offense. Now, felony cases are divided into 5 categories. We'll start at the top and work our way on down to the bottom. We have the capital murder, first degree felony, second degree felony, third degree felony, and the state jail felony. Now, the state jail felony, if a person is convicted of a state jail felony, the range of punishment is minimum 6 months to maximum 2 years in the state jail, and a fine that does not exceed $10,000. Now, if a person is convicted of a third degree felony, the range of punishment is minimum 2 years to a maximum 10 years, and a fine that does not exceed $10,000. If a person is convicted of a second degree felony, the range of punishment is minimum 2 years to maximum 20 years, and a fine that does not exceed $10,000. If a person is convicted of a first degree felony, the range of punishment is minimum 5 years to a maximum of 99 years to life in the state penitentiary, and a fine that does not exceed $10,000. And if a person is convicted of the highest felony, which is a capital murder, the range of punishment, if they're convicted, is life in the state penitentiary without the possibility of parole or death by lethal injection. Now, as I mentioned to you earlier, your offense is a misdemeanor offense, so you don't have to worry about those type of punishments. Now, misdemeanors are divided into 3 categories. We'll start at the top, work our way on down to the bottom. You have the class A misdemeanor, the class B misdemeanor, and the class C misdemeanor. Now, if a person is convicted of a Class C misdemeanor, the range of punishment is by a fine only. They cannot be given jail time, and the fine cannot exceed $500. Now, for example, a Class C misdemeanor is a speeding ticket, or not wearing your seatbelt, or having an expired license tag. Those cases start in the JP court or the city court. They only come to this court when the person is found guilty in that court, and they'll file an appeal, and the case comes to this court, and they get a whole new trial. The range of punishment does not change. It's still the same, which means that if you are convicted, you could be given a fine that does not exceed $500. Now, if you fail to pay the fine, or if your fine was converted to community service and you fail to perform the community service, the court can issue what we call a capious profile. That basically means that it's a warrant for your arrest to either pay the fine or sit the fine out in jail. And if you sit the fine out in jail, you're credited at $100 per day for every day that you sit in jail for the fine. Now, the next highest misdemeanor above the Class C is the Class B misdemeanor. With the Class B misdemeanor, the range of punishment is minimum 0 days to a maximum of 180 days in the county jail, or a fine that does not exceed $2,000, or you could be given both jail time and a fine. Now, the highest misdemeanor is a Class A misdemeanor. The Class A misdemeanor, the range of punishment is minimum 0 days to a maximum of 365 days, or a fine that does not exceed $4,000, or you could be given both such fine and confinement. And just for an example, a Class A misdemeanor could be like unlawful carrying a weapon. That could be a Class C misdemeanor. Resisting arrest could be, those are Class A misdemeanors. There are Class A misdemeanors, resisting arrest, or unlawful carrying a weapon, the Class A misdemeanor. A Class B misdemeanor, for example, could be a criminal trespass. Somebody's hanging out in a store or somebody's property, told them to leave, they refuse to leave. That's a Class B misdemeanor. Or DWI first. First time you get a DWI, it's below a point. It's below a 0.15 blood alcohol. That's a Class B misdemeanor. Now it goes up to a Class A misdemeanor when it's 0.15 or more, or if it's your second DWI. So those are Class A and Class B misdemeanors. All right. Now, everyone that's here for a case, you have rights, okay? And I'll talk to you about some of the rights that you have. One of the rights that you have is the right to have an attorney. The clipboard that has been handed out, everyone who's here for a case should have a clipboard. I'm going to go over that clipboard, the paperwork on that clipboard with you. The first document should be judge's explanation of rights to defendant without an attorney. Make sure that's the first document that we should be everyone should be looking at. On that document, it states that as a defendant in a criminal case, you have three options. Three options regarding your right to have an attorney. Number one, you may hire an attorney. Number two, you may request that an attorney be appointed to represent you. And number three, you may represent yourself. Now, the remainder of this document explains each one of those rights. The first paragraph, below number 3, states that if you like to have an attorney and you have enough money to hire an attorney, your case will be reset to give you time to hire an attorney. So reset means that you'll be given another court date from today to give you time to hire your lawyer. The next paragraph says that if you want an attorney, but you do not have enough money to hire an attorney, you may request that an attorney be appointed by the court to represent you. But you must first fill out a financial questionnaire. Now, a financial questionnaire is another document on that clipboard. It's a 3-page document. that is titled Jefferson County Affidavit of Indigence. It's a 3-page document. And for those of you who would like to apply for a court-appointed attorney, you will have to fill out the first page of that document. And then on the second page, at the top, it says defendant's oath. You'll fill that out. And then in the middle portion where it says unsworn declaration of defendant, you will fill that out and stop. Okay, now let's go back to the judge's explanation. Now the third paragraph states that you may not speak to the prosecutor, and let me explain what that basically means. For those of you who would like to represent yourself, you will have an opportunity to speak to the prosecutor. Prosecutors are assistant criminal district attorneys. We have 2 of them in court today. We have Andrew and Shane. If you like to represent yourself, you will have an opportunity to talk to one of the prosecutors to see if you can work out a plea bargain. A plea bargain is a way where you settle your case. And you cannot do that unless you first sign a waiver of your right to have an attorney. Now, a waiver of the right to have an attorney is another document that's on that clipboard. And it is titled Waiver of Counsel for Purposes of Entering a Guilty Plea or Proceeding to Trial. Now, you would have to read and sign that document and date it. And then you will have an opportunity to talk to one of the prosecutors. The reason why you would have an opportunity to talk to one of the prosecutors, because at that point, when you waive your right to have an attorney, you are representing yourself, so you are acting as your own attorney. Okay? Now, let's go back to the first document, judge's explanation of rights to defendant without attorney. Now, the next to the last paragraph states that for those individuals who like to represent themselves, you should be aware that there are dangers and disadvantages of self-representation. Waiving your right to an attorney and representing yourself may result in a worse outcome for you and your case, including the loss of significant rights and opportunities related to military service, possession of a firearm, housing and public benefits, child custody, immigration status for non-citizens, and employment. Now, if you choose to represent yourself, you may change your mind at any time and request that an attorney be appointed to represent you. All right. Now, at the bottom of that document, in bold letters, it states defendant's choice. Now, everyone is going to make one of the choice, make a choice. Okay. If you would like to hire your own attorney, then you will place your initials on the first line to the left. Sign the document, date it, and then you stop. If you've already hired an attorney to represent you, then you will place your initials on the second line to the left, the name of the attorney on the line to the right, sign the document, and date it, and then you stop. Now, if you would like to apply for a court-appointed attorney, then you will place your initials on the third line to the left. And then, as I mentioned to you earlier, you would have to fill out that document that states at Jefferson County Affidavit of Indigence, the first page, the top portion where it says defendant's oath, and the unsworn declaration of amendment, and you stop. Now, if you have already been appointed a court-appointed attorney, then you will place your initials on the fourth line to the left and the name of the attorney on the line to the right. Then you sign the form where it says defendant, date it, and stop. Now, for those individuals who would like to represent themselves, you will place your initials on the fifth line to the left. Then sign this document, date it, and then you have to read and sign the document that is titled Waiver of Counsel for Purposes of Entering a Guilty Plea or Proceeding to Trial. Does anyone have any questions? Okay. All right. Now I'm going to give you time to fill out those documents. The next right that you have is your right to have an attorney. Now, when this young lady is sitting in that area, we call that the jury box. You have a right to have a jury trial, okay? 6 citizens from Jefferson County will be selected to serve as jurors in your case. They will listen to the evidence, to the arguments, deliberate, and they will decide to find you either not guilty or guilty of your charge. You have a right to waive or give up your right to have a jury trial, and that simply means that you will not be having a jury trial. So if you waive your right to have a jury trial, then your case will come before the judge or the court in one of 3 ways, okay? One of the ways it can come before the judge is by way of a trial. And somebody might say, how can it come by way of a trial if I waive my right to a jury trial? Well, it will come before the court by way of what we call a bench trial. It's a trial by judge only. Well, the judge will be the judge and the jury in the case. The judge will listen to the evidence, listen to the arguments of the attorneys, and the judge will apply the facts to the law and decide to find you either not guilty or guilty. The other way that your case can come before the court is by way of a plea bargain. Now, a plea bargain, as I mentioned to you earlier, is an agreement that you work out with the state to settle your case. All right. Now, if you enter a plea of guilty or no contest, then you'll be entering into a plea bargain. If you enter into a plea of guilty, you're telling the court that you committed the offense that you've been charged with. If you enter a plea of no contest, you're telling the court that you would not be contesting the charges, or you would not be fighting the charges. If you enter a plea of not guilty, obviously, you'll be having a trial, either by judge or by jury. Now, if you enter a plea of guilty or no contest and you want to enter into a plea bargain, you can enter into what we call an agreed plea bargain. An agreed plea bargain means that you and the state have reached an agreement concerning your case, and you want the court to settle the case. Now, the court has to do one of 2 things. The judge can either accept or reject the plea bargain agreement. Now, if you worked out a plea bargain agreement with the state and the judge rejected your plea bargain agreement, you can withdraw or you can take your plea back. For example, let's say you and the state has worked out a plea bargain agreement, and the agreement is for you to be on probation. And then it comes before the judge, and the judge said, well, I'm not going to follow that plea bargain agreement. We told the judge, well, since you're not going to follow my agreement, our agreement, I take my plea back. So you can withdraw your plea of guilty at no contest. All right. Now, if the judge does follow the plea bargain agreement, and say within 30 days that you decide that, you know what, I think I've been wrongfully convicted, or the court committed an error by convicting me, I would like to appeal my case. You have 30 days to appeal. Then if you want to appeal your case, after the judge follows the plea bargain agreement, you have to get permission from the judge who followed the plea bargain agreement to appeal your case. If the judge gives you permission, then your case is going to leave this court and go to the Ninth Court of Appeals, which is located right above us on the 3rd floor. There are 4 judges up there. They will review your case. They can either grant or deny your appeal. If they grant your appeal, they can simply find you not guilty. Case over. Or they can send the case back down to this court, or to this court to give you a whole new trial. Now, if they deny your appeal, then that's not the end, because you can appeal your case to a higher court than the Ninth Court of Appeals. You can appeal your case to the Texas Court of Criminal Appeals, which is located in Austin, Texas, which is the highest criminal court in the state of Texas. Now, you have to file what we call a pro se petition for discretionary review. What that means is pro se means you represent yourself. You don't have a lawyer. And you'll be asking them to, you'll be petitioning them to review your case to see whether or not your appeal should have been granted, or whether or not we committed an error or you were wrongfully convicted in this court. They can do one of 2 things. They can grant or deny your petition. Now, if they grant your petition, they can simply find you not guilty. Case is over. Or they can send it back to the Ninth Court of Appeals with orders, or they can send it back to this court with orders to give you a whole new trial. Now, if they deny your petition, then at that point, your conviction will stand. All right. Now, the other right that you have is the right to have an unagreed plea bargain. Let's say you and the state have talked, but you don't like what they offer. Let's say the state said, well, we want to offer you 40 days in jail or something like that. You say, well, I don't want 40 days in jail. I want the judge to assess my punishment. In essence, we don't have an agreement. We call that an unagreed plea bargain. And the judge decides what your punishment will be based on the punishment range of the offense. All right. Now, the other right that you have, you see that chair there, that's, you have a microphone in front of it, we call that the witness stand. And witnesses, they come to court, they can testify. You can call witnesses, they can testify for you or against you. If you represent yourself, you can ask some questions, or if you have an attorney representing you, they can ask some questions. We call it either direct examination or cross-examination. Now, you also have a Fifth Amendment right against self-incrimination. Well, before I do that, let me do this here thing. You have a right to call witnesses. You have a right to waive your right to call witnesses. If you waive your right to call witnesses, that simply means that you will not be calling witnesses in your case. It does not mean that the state will not be calling witnesses, because they will be calling witnesses. Now, you have a Fifth Amendment right against self-incrimination. I know most of us look at television, we see television shows like Law and Order, and we see where maybe somebody is in court on the witness stand, and the lawyer wants to ask a question. They say, well, I'll take the fifth. Okay. Or you see the police officer want to ask somebody, say, well, I'll take the fifth. I want my lawyer. Okay. What they're saying is they're exercising their Fifth Amendment right against self-incrimination and right not to incriminate themselves. They don't have to say nothing. Okay. And so they remain in silence. And so you have a right to remain silent. Okay. And that simply means this. The state, the government, the DA's office cannot force you to take the witness stand if you exercise your Fifth Amendment right against self-incrimination. Okay? You can sit there, they can't call you to the witness stand because you're exercising your Fifth Amendment right against self-incrimination. Now, you can waive or give it up. If you waive or give it up, then you're saying that, yes, you will be taking the witness stand. All right? Now, you also have a right to have discovery. And what that means is discovery means you have a right to see the evidence that the state will be using against you. Okay? Before you go to trial, you have a right to have access to the file, the district attorney's evidence. You have a right to your statements, witness statements, police reports, lab reports, audio recordings, video recordings, photos, documents, or any instruments that they may have that they're going to use in your case against you. You have a right to have access to that. That's called discovery. Now, you also have a right to waive or give up your right to have discovery. All right? Now, everyone that's here for a case, you've been arrested, you've been charged, you've been booked into jail, you're out of jail on bond, you're out of jail on a cash bond, which means you pay the full amount of the bond to get out of jail. You're out of jail on a surety bond, which means you pay the bonds on a percentage of the bond to get out of jail. Or you're out of jail on what we call a PR bond or a personal regardless bond, which means that you did not have to pay any money to get out of jail. You was released under your own personal recognizance with a promise to be here today. I've said that to say this. Every day that you spent in jail can be used as credit towards your punishment. Now, the operative word that I use, I said every day. Now, let's say you were arrested or you was booked into jail at 11:59 p.m. last night. And you booked out of jail 12:01 a.m. this morning, 2 minutes later. That's 2 different days, right? So you get credit for 2 days. It's 2 minutes. It's not 48 hours, but it's 2 different days. So you get credit for the 2 different days that you were in jail. So you get credit for 2 days. All right. Now, let's say you spent 5 days in jail, and let's say you and the state worked out a plea bargain agreement where you served 5 days in jail. That means you would not have to serve any more time in jail because you'd be given credit for the time that you've already served. Okay, we call that credit for time served. Now, if you serve 5 days in jail and they're offering 7, that means you would only have to serve 2 days in jail because you already have 5 that we will subtract from the 7, and that leaves 2. Now, every day that you spent in jail, you are credited at $100 per day that can go toward your fine and your court costs. All right? So if you spent 5 days in jail, that's $500 that can be applied to your fine and court costs. So if the state is offering you a plea bargain agreement, fine and court costs are $500, that means you won't have to pay nothing. Why? Because you already have $500, and that has been credited towards you, or that have been credited towards you. Therefore, it will be taxed and retired. You won't have to pay anything. Now, if they offer fine and court costs of $700, you spent 5 days in jail, which is $500. That means you would only have to pay $200. Why? Because you have $500. We take the $500 from the $700. That leaves $200. Now, the $200, you would have to pay that on the day that the case is disposed of. If you cannot pay it, no problem. We can put you on a payment plan. And you can pay it off in monthly installments until it's paid off. Now, maybe your financial situation is such that you still be unable to pay it. No problem. We can convert the $200 to community service. You will receive $12.50 that will go towards your fine and court costs for every 1 hour of community service that you perform in a nonprofit organization in our community. Now, and just for example, if you owe $200, if you work 8 hours community service in 1 day, that's $100. So in my scenario, if you work 2 8-hour days, that's $200, and your balance is paid off. Okay. Now, Jefferson County has a program for first-time offenders. If you haven't been in trouble before, they have a program that is called, when I say Jefferson County, I'm talking about the district attorney's office. They have a program that is called pretrial diversion. With pretrial diversion, they will dismiss your case. And you could get it expunged, which means wiped off, erased, or deleted from your record. And the way it works is like this. It has to be your first time getting in trouble. Cannot be an offense for unlawful carrying weapons or resisting arrest. And you have to have an attorney to assist you with the application process to get into the program. Once you get in the program, case dismissed. Once you complete the program, then you can get what we call an expulsion, where it's wiped off, deleted, or erased from your record. All right. If you're a veteran of any one of the branches of the United States military, the district attorney's office has another program for veterans. It's called Veterans Court. Only thing you have to do is be a veteran of any one of the branches of the United States military to get into the program. And what they'll do is you get into the program, you complete the program, they'll dismiss the case, and then you could get what is called a non-disclosure. A non-disclosure is basically your record is sealed. Okay? It's sealed to the general public. So the general public cannot open it, they cannot have access to it. Now, the operative word that I use is general public. Now, the government can have access, but the general public, which is most of the public, cannot have access. This court, County Court at Law Number 2, Jefferson County, Texas, has a program that God led me to start in the first 100 days of taking office. in March of 2017. The program is called the Community Safety Initiative, commonly referred to as the CSI program. With that program, the program is designed to address the issue of what we call recidivism. Recidivism just simply means people commit crimes over and over, reoccurring. And so the way we address that problem is with the Community Safety Initiative. We have partnerships with agencies in our community. One of the agencies that we have a partnership with is the Spindletop Center. And they're gonna come to you a little later in a few minutes and tell you more about the program. But basically, the Spindletop Center is our local mental health center. They have the experience and expertise to address individuals who have mental health issues. Now, you do not have to be incompetent or insane to participate in the program. You can just simply suffer from anxiety or depression or any other host of mental illnesses. And Spindletop have the ability to address those issues. Now, what they will do, they can do what we call a private interview, either in our jury room, at their facility, or by telephone, or whichever is convenient with you. Then they can develop an assessment, they can do an assessment, and then they can develop a treatment plan to address your mental health issues. If you have issues, and sometimes people have issues with drugs or alcohol, they have a program, Spindletop has a program that is called ATAR. A is an acronym that's ATAR, and it stands for Addiction, Treatment, and Recovery. We also have a partnership with our local drug and alcohol council that has a program that is called OSAR, OSAR, which is an acronym that stands for Outreach, Screening, Assessment, and Referral. Both of those programs are drug and alcohol recovery programs. And what they will do a private screening, an assessment, and develop a treatment plan to address your alcohol or drug issues. Now, it's not uncommon for individuals who have issues with either alcohol or drugs to also have a mental problem, or have a mental problem, have issues with drugs and alcohol. Because a lot of times people want to, what we call self-medicate, okay? And that's not uncommon. If you are unemployed, or you're looking for a better job, well, we have a partnership with Lamar University, with the Golden Triangle Empowerment Center, who has a partnership with Lamar University. Now, Lamar University has a program that is called CICE. It's an acronym that stands for Center for Innovation, Commercialization, and Entrepreneurship. It's a job training and a job placement program in the hotel industry, the shipping industry, and the chemical industry. What they will do is, once you are trained in any one of the areas that you select, they will help you to get a job in the area that you're trained in. And let me stop right there, because I know a lot of times people, they get training and then they go and try to get a job on their own, and they don't get the job. And sometimes because they say, well, they might have a criminal record or something like that, but CICE, because of their track record, they could get you in doors that have been closed to you, okay? So that's one of the beauties, one of the good things about being in a program like that. They have access to get you into the plants, to get you into the jobs, or the different jobs that you would like to have. They can get you in. All right. Now, if you have not graduated from high school, or you do not have your GED, CIC also have a graduate equivalency diploma program, GED program. And well, you can get your GED. Now, all of these programs that I just mentioned to you are free. Does not cost you anything but time. And I like to say in this court, we do not just give time, we take our time. That is, we do not just arrest the problem, we address the problem. And we believe that if we address the problem, we can produce productive people, And if we produce productive people will not commit crimes. Why? Because they have too much to lose. And so therefore, I like to say, when you come to county court at 1102 in Jefferson County, Texas, we do not just have court as usual. We have unusual court. And it's not because we're different, but it's because we're trying to make a difference in the lives of the individuals that come before this court. And if we make a difference in their life, we will make a difference in their home. And if we make a difference in their home, we will make a difference in the community, because what comes out of the home goes into the community. And so if you're interested in any one of these programs, just let us know. We have brochures that we can give to you, or you can make contact with individuals that can help you to get in any one of these programs that I've just mentioned. Now, as I mentioned to you earlier, we have some folks from Spindletop. They're going to come to you and tell you a little bit more about their program that they have to offer. We have Deputy Hinton and we have Caitlin. They're from Spindletop. Deputy Hinton, Caitlin.
Thank you, Your Honor. Good morning. As the judge was speaking, my name is Steve Hanna, I'm a mental health deputy licensed by the state commission here with the sheriff's department. This is my coworker, Caitlin. Now, Caitlin is a qualified mental health professional. The reason we are both here this morning in this courtroom is because the judge cares about every single person that comes before the bench. What the judge has found and what statistics prove is those who have legal issues commonly have mental health needs, substance use disorders, or sometimes just a lack of community resources to help you in your particular situation. Now, maybe this is your first time to be in court, could be your fifth time to be in court. There's still hope. In fact, what we're offering you today has the ability to change your life, but we're going to need something from you. We're going to need you to share that need with us so we can see best how to advocate and help you in your particular situation. And Caitlin will explain exactly how you can do that great.
And the picture that I passed out to everyone when they walked in, at the top is basic information, his name, and phone number, and email. We need those things to put you into our system. And then under that is how you'd like to be contacted, and the options are call, text, or email. Whatever you check is how to contact you. I will not contact you any other way unless you check it on this form. Under that is what you need help with, and most of these resources is I email you links, and you have to do them yourself. But if you were to check mental health, it could be depression, anxiety, or PTSD, or if you check substance use, which could be any type of drug or alcohol, then you work hand in hand with Spindletop, and we get you the resources and the services that you need to do that. Everything else is pretty much self-explanatory. If you want to talk to me today in person, you can write anywhere on your paper to talk to me today. And once the judge is done with you, he'll call you up, do what he needs to do, and then I will come and get you and pull you to a back room and we can talk. But if you just want me to call you today or anytime this week, you can put that on the phone as well.
Now, one of the first resources I can actually provide for you today is this business size card. It has a 1-800 number on there. If you ever find yourself in an unsafe place, you can get help immediately, and that will be the first resource we can provide for you. Now, just shortly, the court's going to go into recess. When it does, we'll be able to come out there, we'll visit with you, we'll answer any questions you have. I'll be giving this to everyone who wants one, and we'll be picking up those documents for those who wish to fill it out and hand to us.
Thank you, Deputy
Thank you,
Henry.
Ron.
Thank you, Deputy Henry. Now, ladies and gentlemen, as Deputy Henry mentioned, in a few minutes, we're going to be going into recess. And that will give you an opportunity to finish filling out the paperwork that you have. Now, it's going to take some time for everyone to fill out the paperwork. If you need to use the restroom, there are two restrooms right in the hallway. One, the men's restroom is in front of County Court 103, which is right next door. And on the opposite side of the hallway is the women's restroom in front of the 172nd District Court. Now, you'll have an opportunity to use the restrooms. And you come back into the courtroom. Please do not leave the courthouse. If you leave the courthouse and your name is called, then a warrant can be issued for your arrest. Because your bond will be forfeited, and a warrant will be issued for your arrest, and then we have to go through this process all over again. All right. Now, if you need help with the paperwork, We have our full personnel, including me, who will be, happy to help you with completing the paperwork. Now, as I mentioned to you earlier, well, I didn't mention, but you were in court. And so when we go into research, in the recess, please conduct yourself accordingly, so that we can get through this process as smooth and as fast as possible. Okay. And if you have any questions, just, let us know, and then, we'll have someone to come out and be able to answer any questions that you have, okay? So at this time, we're going to go into recess. Jefferson County Court at Law number 2 is back in session. The court is in session with the arraignment docket. First case is cause number 25CCCR0150. Case is styled the state of Texas versus Christian Dominic White. Mr. White, would you please come forward? Mr. White, your full name is Christian Dominic White. Mr. White, would you please raise your right hand? Mr. White, do you swear or affirm to tell the truth, the whole truth, and nothing but the truth, so help you God? Mr. White, you may put your hand down. How are you doing, Mr. White? Good. That's good. Now, Mr. White, I have before me a document that is titled Judge's Explanation of Rights to Defendants Without Attorney. Do you recognize this document? Yes. Is this your signature on the line that's titled Defendants? Sure. And are these your initials on the line that state you'd like to have your case reset to hire your own attorney? Now, before you signed and initialed this document, did you read the document? Did you understand what you read? Sure. And is everything in this document true and correct to the best of your knowledge? Okay. And Mr. White, your case is going to be reset to give you time to hire your own attorney. You're gonna have a seat in that first chair on the wall, and the court coordinator is gonna reset your case. Once she resets your case, you're gonna go to the window of the court coordinator. Just have a seat in that first chair. Next two cases are cause numbers 25CCCR0104 and cause number 25CCCR0105. Both cases are styled in the state of Texas versus Jacob Madison. Mr. Madison, would you please come forward? Mr. Madison, your full name is Jacob Madison? Yes, sir. Mr. Madison, would you please raise your right hand? You swear or affirm to tell the truth, the whole truth, and nothing but the truth, so help you God? Yes, sir. You may put your hand down. How are you doing, Mr. Madison? I'm okay. What about yourself? I'm doing fine. Thanks for asking. Mr. Madison, I have before me two documents. The first document is titled Judge's Explanation of Rights to this document is titled Judge's Explanation of Rights to Defendants Without Attorney. You recognize this document? Yes, sir. Are these your initials on the line that state you have hired Wendell Radford? Yes, sir. And is this your signature on the line that's titled Defender? Yes, sir. Before you signed and dated this and initialed this document, did you read the document? Yes, sir. Did you understand what you read? Yes, sir. Is everything in this document true and correct to the best of your knowledge? Yes, sir. Okay. Mr. Madison, your case is going to be reset. Attorney Radford is going to send the court a letter of representation. Yes. You raising your hand?
Yes, I'm sorry, I'm just running, and we have an appointment with Radford right after we leave here.
Oh.
And I spoke with him this morning, and he asked if we could possibly reset it for next week.
Well, it's gonna, they just need a 1 week reset?
Yes.
Oh, okay. Okay, so your case is gonna be reset to give you an opportunity and give Mr. Radford an opportunity to send the court a letter of representation. Yes, sir. Informing the court that he has been hired to represent you. Now, our court coordinator is going to give you that reset. But before she gives you that reset, I need to give you some bond conditions. Mr. Pickens, could you hand me the bond conditions to Mr. Madison? Okay, Mr. Madison, the document that you have before you is titled Standard Bond Conditions in County Court at Law number 2. Do you see that title? Yes, sir. Okay, and it states as follows: following the return of a criminal information in County Court at Law number 2 of Jefferson County, Texas, all bail bonds executed for release of any defendant named herein are ordered subject to the additional conditions. Number 1, defendant shall commit no offense against the laws of this state any other state or of the United States. Do you understand that condition?
Yes, sir.
Condition number 2, defendant shall submit to testing for drugs and alcohol at any time as directed by the court. The court may revoke the bond and order the arrest of any defendant who A, refuses to submit to a test for drugs and alcohol when directed to do so by the court, or B, submit to a test for drugs and alcohol in the test in the case the presence of drugs or alcohol in the defendant's body. You understand that condition?
Yes, sir.
And condition number 3 and condition number 3 does not apply. And condition number 4 doesn't apply because that only applies to the DWI case. However, condition number 5 on the second page does apply, and it says defendant is prohibited from possessing firearm or ammunition unless defendant is a peace officer as defined by section 1.07 of the Penal Code, actively engaged in employment as a sworn, full-time paid employee of a state agency or political subdivision. Do you understand that condition?
Yes, sir.
Okay, now, Mr. Madison, if you violate these conditions, any one of these conditions, your bond can be revoked. And if your bond is revoked, the warrant will be issued for your arrest. You'll be arrested and placed in the Jefferson County Jail. Do you understand?
Yes, sir.
Okay. Have a seat in that first chair and wait for your name to call. Once your name is called, you'll be free to go. And you have a blessed day.
Yes, this is Mr. Castle's paperwork. He's playing on one, I believe he's seeking for a point on the other.
Okay,
What's happening?
I think he's in the back. Joshua Simeon. Okay, Mr. Simeon, would you please raise your right hand? Mr. Simeon, do you swear or affirm to tell the truth, the whole truth, and nothing but the truth so help you God?
Yes, sir.
Mr. Simeon, you may put your hand down. How are you doing, Mr. Simeon?
Doing good.
I'm doing fine, thanks, Fax. Now, Mr. Simeon, I have before me a document that is titled Judge's Explanation of Rights to Defendants Without Attorney. You recognize this document?
Yes, sir.
And is this yours? Did he sign it? He didn't sign it. He didn't sign and date it.
No.
Okay, now, Mr. Simeon, is this your signature on the line that's titled defendant?
Yes, sir.
And are these your initials on the line state you'd like to apply for court-appointed attorney?
Yes, sir.
I also have another document that is titled Jefferson County Affidavit of Indigence. Do you recognize this document?
Yes, sir.
On page 2 of this same document, there's a signature above the line that is titled defendant signature. Is this your signature?
Yes, sir.
Mr. Simeon, before you sign and initial these documents that I just showed you, did you read the documents?
Yes, sir.
Did you understand what you read?
Yes, sir.
And is everything in these documents true and correct to the best of your knowledge?
Yes, sir.
Okay, Mr. Simeon, I read your answers. Based on your answers, you meet the eligibility requirements for the appointment of a court-appointed attorney. And the attorney that will be appointed to represent you in this case is Attorney Jennifer DeLodge. Attorney DeLodge will be given information to contact you, and you will be given information to contact her. Our court coordinator will give you that information. Once she gives you that information, you'll be free to go,
Yes, sir.
and you have a blessed day.
Thank you, sir. You-
Please have a seat in that first chair on the wall and wait for your name to be called.
Yes, sir.
Joseph Rubin. Okay, quoted in session in 2 cases, cause numbers 25 CCCR 0134 and cause number 25 CCCR 0136. Both cases are styled the state of Texas versus Joseph R. Rubin III. Mr. Rubin, is that your full name? Mr. Rubin, would you please raise your right hand? Mr. Rubin, do you swear or affirm to tell the truth, the whole truth, and nothing but the truth, so help you God? Mr. Rubin, you may put your hand down. How are you doing, Mr. Rubin? I'm doing fine, thanks for asking. Mr. Rubin, I have before me two documents. The first document is titled Judge's Explanation of Rights to Defendants Without Attorney. You recognize this document? Is this your signature on the line that's titled Defendant?
Yes,
Or these your initials on the line that state you like to apply for a court-appointed attorney?
sir.
I have another document that is titled Jefferson County Affidavit of Indigence. Do you recognize this document? On page 2 of the same document, there's a signature above the line that is titled Defendant. Is this your signature?
Yes, sir.
Now, Mr. Rubin, before you signed and initial these documents, did you read the documents?
Yes, sir.
Did you understand what you read?
Yes, sir.
And is everything in these documents true and correct to the best of your knowledge? Okay, Mr. Rubin, I read your answers. Based on your answers, you meet the eligibility requirements for the appointment of a court-appointed attorney. And the attorney that will be appointed to represent you is Attorney Ryan Matuska. Attorney Matuska will be given information to contact you, and you will be given information to contact him. Our court coordinator will give you that information. But before she gives you that information, Deputy Pickens is going to hand you a document that is titled Standard Bond Conditions in County Code at Law Number 2. Do you see that title?
Yes, sir.
Okay, I'm going to go over these bond conditions with you, and it states as follows. Following the return of accruing information in County Code at Law Number 2 of Jefferson County, Texas, all bail bonds executed for release of any defendant named herein or ordered subject to the additional conditions. Number 1, defendant shall commit no offense against the laws of this state, any other state, or of the United States. Do you understand that condition? Condition number 2, defendant shall submit to testing for drugs and alcohol at any time as directed by the court. The court may revoke the bond and order arrest of any defendant who A, refuses to submit to test for drugs and alcohol when directed to do so by the court, or B, submit to a test for drugs and alcohol, and the test indicates the presence of drugs and alcohol in the defendant's body. Do you understand that condition?
Yes, sir.
And condition number 3 does not apply. And condition number 4 does not apply because that only applies in the DAI case. However, condition number 5 does apply. And condition number 5 states that the defendant is prohibited from possessing a firearm or ammunition unless the defendant is a peace officer as defined by section 1.07 Penal Code, actively engaged in employment as a sworn full-time paid employee of a state agency or political subdivision. Do you understand that condition? Okay, Mr. Rubin, if you violate any one of these conditions, your bond can be revoked, and if your bond is revoked, warrant will be issued for your arrest. You'll be arrested and placed in the Jefferson County Jail. Now, Mr. Rubin, have a seat, wait for your name to be called. Once your name is called, you go to the one and you'll be free to go and you have a blessed day. Deshaun Mays.
Yes, ma'am. That's fine. Not the one.
Mr. Mays, your full name is Deshaun Montreal Mays. Ms. Mays, would you please raise your right hand? Do you swear or affirm to tell the truth, the whole truth, and nothing but the truth, so help you God? Mr. Mays, you may put your hand down. How are you doing, Mr. Mays? I'm doing fine, thanks for asking. Now, Mr. Mays, I have two documents before me. The first document is titled Jefferson County Affidavit. Well, the first document is titled Judge's Explanation of Rights to Defendants Without Attorney. Do you recognize this document?
Yes, sir.
Is this your signature on the line that's titled Defender?
Yes, sir.
And are these your initials on the line that state you like to apply for a court-appointed attorney?
Yes.
I have another document that is titled Jefferson County Affidavit of Indigence. Do you recognize this document?
Yes.
On page 2 of the same document, there's a signature above the line that is titled Defendant Signature. Is this your signature?
Yes.
Mr. Mays, before you sign and initial these documents, did you read the documents? Did you understand what you read? And is everything in these documents true and correct to the best of your knowledge? Okay, Mr. Mays, I read your answers. Based on your answers, you meet the eligibility requirements for the appointment of a court-appointed attorney, and the attorney that will be appointed to represent you in this case is Attorney Lori Perazzo. Attorney Lori Perazzo will be given information to contact you, and you will also be given information to contact her. Our court coordinator will give you that information. Once she gives you that information, you'll be free to go and you have a blessed day. Please have a seat in that second chair on the wall. Shamara Hendry. Ms. Henry, your full name is Shamara Henry? Yes. Ms. Henry, would you please raise your right hand? Ms. Henry, do you swear affirm to tell the truth, the whole truth, and nothing but the truth, so help you God? Yes, sir. Ms. Henry, you may put your hand down. How you doing, Ms. Henry? I'm doing fine, thanks for asking. Now, Ms. Henry, I have before me two documents. The first document is titled Judge's Explanation of Rights to Defendants Without Attorney. You recognize this document? Yes, sir. Is this your signature on the line that's titled Defendant? Yes, sir. And are these your initials on the line that state you like to apply for court appointed attorney? Yes, sir. I also have another document that is titled Jefferson County Affidavit of Indigenous. You recognize this document? Yes, sir. And is this your signature on the line that's titled Defendant? Yes, sir. Now, Ms. Henry, before you sign and initial these documents, did you read the documents? Yes. Sir. You understand what you read? And is everything in these documents true and correct to the best of your knowledge? Yes. Okay, Mr. Henry, I read your answers. Based on your answers, you meet the eligibility requirements for the appointment of a court appointed attorney. And the attorney that will be appointed to represent you is Attorney Marva Provo. Attorney Provo will be given information to contact you, and you will also be given information to contact her. Our court coordinator is going to give you that information. Once you get that information, you'll be free to go and you have a blessed day. Please have a seat in that third chair on the wall. Oh, I need. Mr. Bridges. Okay, this is cause number 25 CCCR 0176. Case is styled the state of Texas versus Misty G. Bridges. Ms. Bridges, is that your full name?
Yes, sir.
Ms. Bridges, would you please raise your right hand? Ms. Bridges, do you swear or affirm to tell the truth, the whole truth, and nothing but the truth, so help you God?
Yes, sir.
Ms. Bridges, you may put your hand down. How are you doing, Ms. Bridges?
Nice to you.
I'm blessed as well. Thanks for asking. Ms. Bridges, I have before me two documents. Now, before we get started, Ms. Bridges, you have a right to have a court reporter to dictate everything that's being said in your case. Or you also have a right to waive your right to have a court reporter. Now, do you waive your right to have a court reporter?
Yes, sir, I do.
Oh, you do, okay. Ms. Bridges, I have before me on my computer a document that is titled information. This information alleges that on or about March 26th of 2024, while you were in Jefferson County, Texas, that you committed that you committed the Class A misdemeanor offense of driving while intoxicated with an alcohol concentration level of 0.15 or more. Specifically, this document alleges that on or about March 26th of 2024, while you operated a motor vehicle in a public place in Jefferson County, Texas, that you committed the Class A misdemeanor driving while intoxicated with an blood alcohol concentration of 0.15 or more. Ms. Bridges, do you understand what you have been charged with?
I do.
And to this charge, Ms. Bridges, how do you plead? Guilty, not guilty, or no contest?
No contest.
Are you pleading no contest freely and voluntarily?
Yes, I am.
And are you pleading no contest because you do not wish to fight or contest the charges?
Yes, sir.
Ms. Bridges, I also have before me document that is titled Judge's Explanation for Rights to Defendants Without Attorney. You recognize this document? And is this your signature on the line that's titled Defendant?
Correct.
Are these your initials on the line that state you would like to represent yourself
Yes, correct.
and waive your right to an attorney? I also have a document that is titled Waiver of Counsel for Purposes of Entering Guilty Plea or Proceeding to Trial. Do you recognize this document?
Yes,
Is this your signature on the line that's titled Defendant?
yes, sir.
Now, before you signed and initialed these documents, did you read the documents?
I-
Did you understand what you read?
Yes,
Is everything in these documents true and correct to the best of your knowledge?
yes.
Ms. Bridges, I also have before me on my tablet a document that is titled Misdemeanor Plea Admonishments. Do you recognize this document?
I do.
On page 2 of the same document, there are two sets of initials. First set of initials is below a paragraph that is titled Waivers, and it's next to a line that's checked no contender, which means no contest. You place your initials on this document.
Yes, sir.
The second set of initials is below a paragraph that is titled Discovery Admonishment, and the initials are on a line next to a statement that reads, I do not request discovery of the evidence. I waive my right to request discovery in this case and choose to enter a plea of guilty and no contest. Did you place your initials here as well?
Yes, sir.
On page 3 of the same document, there's a signature above the line that's titled Defendant. Is this your signature?
Yes, sir.
The next document is titled Trial Court Certification of Defendant's Right of Appeal. Do you recognize this document?
Yes, sir.
And is this your signature on the line that's titled Defendant?
Yes, sir.
At the top of this document, there are two boxes checked. The first box that's checked states that this is a plea bargain case and you have no right of appeal. You understand that statement?
Yes, sir.
The second box that's checked states that you're waiving your right to an appeal, which means you're giving up your right to an appeal. Do you understand that statement?
Yes, sir.
Now, before you sign and initial these documents, did you read the documents?
Yes, sir.
Did you understand what you read?
Yes, sir.
Is everything in these documents true and correct to the best of your knowledge?
Yes, sir.
Ms. Bridges, are you a citizen of the United States?
Yes, sir.
Several
State.
states one.
Now, Ms. Bridges, the state is offering State's Exhibit number 1 to be used as evidence against you in your case. Now, State's Exhibit 1 is this document, the first document that I showed you on the tablet, that is titled Judge's Explanation of Rights to Defendants Without Attorney. Well, misdemeanor plea admonishment. And on page 2, this is the same docket that have your initials in these 2 locations. And have your signature, it has your signature on page 3. The state would like to use this document as evidence in your case. Is it all right for the state? Okay, no objection. State's exhibit number 1 is admitted. Now, Ms. Bridges, is there any evidence that you are currently mentally incompetent to stand trial? Ms. Bridges, I will accept your plea of no contest. I will find that you are mentally competent to stand trial. I will also find that your plea and waivers were freely and voluntarily given. And I will also find that there is sufficient evidence to find you guilty beyond a reasonable doubt. State. Do we have a plea bargain agreement?
We do, Your Honor.
Okay. And what is the agreement?
The agreement in this case is to 90 days probated over 1 year with a $500 fine, 60 hours community service, the installation, maintaining an interlock device, and DWI standard conditions of probation, as well as $250 restitution to Wesley Eves.
You said 250 restitution.
Yes, Your Honor. They will also be given credit for 1 day in jail towards finding court costs.
Says $100 credit, 1 day credit. What's the court cost in this case? 377. So this is. Okay, Ms. Bridges, the state is offering that you serve 90 days in Jefferson County Jail, but you will not have to serve any time in the Jefferson County Jail because you'll be placed on probation for a period of 1 year. During the 1 year probationary period, you'll be required to pay a fine of $500 plus court costs of $377. You'll be required to pay a DWI fee of $100. You'll be required to pay probation fee of $60 a month, your analysis fee of $15 a month, reimbursement fee of $15. You will also be required to pay Jefferson County DWI education and initial evaluation fee of $125 on the day of the plea. Should a further evaluation be needed, you'll be required to pay an additional $50. Now, your month also, you'll be given credit for 1 day towards your fine and court costs. So your current monthly installments, that is the total amount that you would have to pay each month, is $163 a month.
Yes, sir.
Will you be able to pay the $163 each
Yes,
month?
sir.
You will also be required to perform 60 hours of community service. Install an interlock device on any vehicle that you own or operate. Attend and complete a DW education class. Oh, you know what? I didn't do the restitution. Hold on a minute. I forgot to put the restitution in there. It's gonna change.
Like I was saying, that's,
Oh.
no, it's just the probation. Now, if you, the probation, violate your probation, that's the maximum that you're subject to. Like I was saying, it's a cap.
Yeah.
Must be his clipboard, huh? What else? $22. Okay, I just had to make a correction. I didn't add in the restitution. Now, Ms. Bridges, the state is offering that you serve 90 days in Jefferson County Jail, but you would not have to serve any time in the Jefferson County Jail because you'll be placed on probation for a period of 1 year. During the 1 year probationary period, you'll be required to pay a fine of $500 plus court costs of $337. You'll be given credit for the 1 day, which will go toward the fine and court costs. You will also be required to pay a DWI fee of $100, probation fee $6 a month, your announcement fee of $15 a month, reimbursement fee of $15, and you'll be required to pay restitution in the amount of $250 to Wesley Eves. Now, your total monthly installments, that is, the total amount that you will be required to pay each month is $186 a month.
Yes, sir.
Will you be able to pay the $186 each month?
Yes.
You will also be required to perform 60 hours of community service, have an alcohol, where you'll be required to install an interlock device in any vehicle that you own or operate, attend and complete a DW education class, have an alcohol assessment. And again, I'll mention that you're required to pay the restitution to Wesley Eves, and you are given credit for the 1 day toward your, that you spent here toward your fine and court costs. And you will also be required to adhere to the other standard terms and conditions of your probation. Ms. Bridges, do you understand the state's offer?
I do.
Do you think the state's offer in your case is fair and just?
Yes, sir.
And do you accept the state's offer?
I do.
Ms. Bridges, I'll follow the plea bargain agreement that you have entered into with the state. Ms. Bridges, this will conclude your case. Ms. Bridges, just stand before the court coordinator,
Yes, sir.
follow directions of the bailiff. Once you finish following the directions of the bailiff, you're free to go and you have a blessed day. You're welcome. Y'all have some. Y'all had a paperwork on the next case. Damon Johnson. Yeah, no, SL, SL. Thank you. Okay. What is the session? When calls number 24 CCCR 1064. Cases style of state of Texas versus Damon Dwayne Johnson. Mr. Johnson, is that your full name?
Yes, sir.
Mr. Johnson, would you please raise your right hand? Mr. Johnson, do you swear or affirm to tell the truth, the whole truth,
Yes, sir.
and nothing but the truth, so help you God?
Yes, sir.
Mr. Johnson, you may put your hand down. How are you doing, Mr. Johnson?
I'm all right. How about yourself?
I'm doing fine, thanks for asking. Mr. Johnson, I have before me on my computer a document that is, well, first of all, I have a document on paper that is titled Judge's Explanation of Rights to Defendants Without Attorney. Now, before we get started, Mr. Johnson, you have a right to have a court reporter to type down or dictate everything that's being said. You also have a right to waive or give up your right to have a court reporter. Do you waive or give up your right to have a court reporter? Okay. Now, Mr. Johnson, I have before me two documents. The first document is titled Judge's Explanation of Rights to Defendants Without Attorney. You recognize this document? Is this your signature on the line that's titled Defendant?
Yes, sir.
Or these are your initials that state you like to waive your right to attorney and represent yourself?
Yes, sir.
I also have another document that is titled Waiver of Counsel for purposes of entering guilty plea or proceeding in trial. You recognize this document?
Yes, sir.
And is this your signature on the line that's titled Defendant?
Yes, sir.
So Johnson, before you sign and initial these documents, did you read the documents?
Yes, sir.
Did you understand what you read? Is everything in these documents true and correct to the best of your knowledge?
Yes, sir.
And Mr. Johnson, I also have before me on my computer a document that is titled Information. This information was filed by the Jefferson County District Attorney's Office. In this information, it alleges that you, Damon Dwayne Johnson, on about March 15th, 2024, while you were in Jefferson County, Texas, that you committed the Class A misdemeanor offense, possession of a controlled substance, penalty group 3, less than 28 grams. Mr. Johnson, do you understand what you've been charged with?
Yes, sir.
And to this charge, Mr. Johnson, how do you plead guilty? Not guilty, no contest.
No contest.
Or you pleading no contest freely and voluntarily?
Yes, sir.
And are you pleading no contest because you do not wish to fight or contest the charges?
Yes, sir.
Mr. Johnson, I also have before me on my tablet a document that is titled Misdemeanor Plea Admonishments. Do you recognize this document?
Yes, sir.
On page 2 of the same document, there are two sets of initials. One set of initials is below a paragraph that's titled Waivers, and the initials are on a line next to a box that's checked no contendere, which means no contest. Did you place your initials on this document?
Yes, sir.
The next set of initials is below a paragraph that is titled Discovery Admonishment, and the initials are on a line next to a statement that reads as follows: I do not request discovery of evidence. I waive my right to request discovery in this case and choose to enter a plea of guilty or no contest. Did you place your initials in this document? On page 3 of the same document, there's a signature above the line that is titled Defendant. Is this your signature?
Yes, sir.
I also have a document that is titled Trial Court Certification of Defendant's Right of Appeal. Do you recognize this document?
Yes, sir.
And is this your signature on the line that's titled Defendant? At the top of this document, there are two boxes checked. The first box that's checked states that this is a plea bargain case and you have no right of appeal. Do you understand that statement?
What is it again?
It states that this is a plea bargain case and you have no right of appeal. Do you understand that statement? The second box that's checked states that you're waiving your right to an appeal, which means you are giving up right to an appeal. Do you understand that statement?
Yes, sir.
Now, Mr. Johnson, before you signed and initialed all of these documents that I showed you, did you read the documents? Did you understand what you read? Is everything in these documents true and correct to the best of your knowledge?
Yes, sir.
Mr. Johnson, are you a citizen of the United States?
State offers States Exhibit 1, Your Honor.
Okay, Mr. Johnson, the state is offering State's Exhibit number 1 to be used against you as evidence in your case. State's Exhibit 1 is the first document that I showed you on this tablet. This is the same document that have your initials in these 2 locations. It also has your signature on page 3. Is it all right for the state to use this document as evidence in your case?
Yes, sir.
Okay, no objections? State's Exhibit number 1 will be admitted. Mr. Johnson, are you a citizen of the United States?
Yes, sir.
Okay. Okay. Now, Mr. Johnson, is there any evidence that you are currently mentally incompetent to stand trial?
No, sir.
Mr. Johnson, I will accept your plea of no contest. I will find that you are mentally competent to stand trial. I will also find that your plea and waivers were freely and voluntarily given. I will also find that there is sufficient evidence to find you guilty beyond a reasonable doubt. State, do we have a plea bargain agreement in this case?
Yes, Your Honor.
And what is the agreement?
Your Honor, we would ask the court for 180 days county jail, probated for a period of 1 year. We'd ask for a fine of $500, 40 hours of community service with repayment of court costs. And we'd ask that the defendant be required to attend and complete a substance abuse class, and then the standard terms and conditions of probation.
Is there a, in this drug case, is there a $100 fee?
Yes.
Okay. What's the court cost? Mr. Johnson, the state is offering that you serve 180 days in Jefferson County Jail, but you will not have to serve any time in the Jefferson County Jail because you'll be placed on probation for a period of 1 year. During the 1 year probationary period, you'll be required to pay a fine of $500 plus court costs of $277. You'll also be required to pay a $100 fee to drug lab. You'll also be required to pay a probation fee of $6 a month, your analysis fee of $15 a month, reimbursement fee of $15. Your total monthly installments, that is the total amount that you will be required to pay each month, is $163 a month. Will you be able to pay the $163 each month?
For a year.
Yeah, well, yeah. Just throughout the duration of your probation. Now, you will also be required to perform 40 hours of community service. You will attend and complete a drug education class. You will also adhere to the standard terms and conditions of this probation. Mr. Johnson, do you understand the state's offer?
Yes, sir.
You think the state's offer in your case is fair and just? Do you accept the state's offer?
Yes, sir.
Mr. Johnson, I'll follow the plea bargain agreement that you have entered into with the state. Mr. Johnson, you will stand in front of the court coordinator, follow her directions, and follow the directions of the bill. Once you finish following the directions of the bill, you're free to go and you have a blessed day. Two five CCCR 0081, case and style of state of Texas versus Sean Robert Cassell. Mr. Cassell, your full name is Sean Robert Cassell.
Yes, sir.
Mr. Cassell, would you please raise your right hand? Swear affirm to tell the truth, the whole truth, and nothing but the truth, so help you God. Mr. Cassell, you may put your hand down. How are you doing, Mr. Cassell?
Doing good. How about you?
I'm doing fine, thanks for asking. Mr. Cassell. Where is this? Okay, now, Mr. Cassell, I have before me two documents. One is titled Judge's Explanation of Rights to Defendants Without Attorney, the other one is titled Waiver of Counsel for Purposes in a Guilty Plea. Now, Mr. Cassell, before we get started, I need to inform you that you have a right to have a court reporter to type down or dictate everything that's being said in this proceeding. You also have a right to waive or give up your right to have a court reporter. Do you waive or give up your right to a court reporter?
Yes.
Now, Mr. Cassell, I have before me two documents. First document is titled Judge's Explanation of Rights to Defendants Without Attorney. You recognize this document? And is this your signature on the line inside of defendant?
Yes, sir.
And are these your initials on the line that state you like to waive your right to an attorney or represent yourself?
Yes, sir, but just
Yes, I only have one case before me.
oh, you know, one case.
Yeah,
Okay.
in this case, are you waiving your right to have an attorney?
Yes, sir. Yes, sir.
The next document states that this is a waiver of counsel for purposes of entering guilty plea or proceeding trial. Do you recognize this document?
Yes, sir.
And is this your signature online inside of defendant?
Yes, sir.
Mr. Cassell, before you sign and initial these documents, did you read the documents?
Yes, sir.
Did you understand what you read?
Yes, sir.
Is everything in these documents true and correct to the best of your knowledge?
Yes.
Mr. Cassell, I also have before me on my computer a document that is titled information. This information was filed by the Jefferson County District Attorney's Office. In this information, it alleges that you, Sean Robert Cassell, on or about October 6th of 2024, while you were operating a motor vehicle in a public place in Jefferson County, Texas, that you committed the Class A misdemeanor offense of driving while intoxicated. Second, state, are you abandoning the enhancement paragraph?
That's correct, Your Honor.
Now, Mr. Cassell, the state is abandoning the enhancement paragraph. And what that means is, instead of being charged with a class A misdemeanor offense, DWI second, you will be charged with a lesser included offense, DWI first, which is a class B misdemeanor. Do you understand that?
Yes.
Now, to the class B misdemeanor offense of driving while intoxicated, which allegedly occurred on or about October 6th of 2024, while you are operating a motor vehicle in a public place in Jefferson County, Texas, how do you plead? Guilty, not guilty, or no contest?
No contest.
Are you pleading no contest freely and voluntarily? And are you pleading no contest because you do not wish to fight or contest your charges? Mr. Cassell, I also have before me a document that is titled Misdemeanor Plea Admonishments on my tablet. This document is also labeled as State's Exhibit Number 1. Do you recognize this document?
Yes.
On page 2 of this same document, there are 2 sets of initials. The first set of initials, SC, are on a line below a paragraph that is checked. There's below a paragraph that is titled waivers, and it's next to a line with a box checked no contingent, which means no contest. Did you place your initials on this document?
Yes.
The second set of initials is below a paragraph that is titled Discovery Admonishment, and it is on a line next to a statement that reads, I do not request discovery of the evidence. I waive my right to discover the evidence in this case and choose to enter a plea of guilty or no contest. You place your initials in this location as well.
Yes.
On page 3 of the same document, there is a signature above the line that is titled defendant. Is this your signature?
Yes.
And on the next document, that's titled Trial Court Certification of Defendant's Right of Appeal. You recognize this document?
Yes, sir.
And is this your signature on the line that's titled defendant?
Yes, sir.
At the top of this document, there are 2 boxes checked. The first box that's checked states that this is a plea bargain case and you have no right of appeal. Do you understand that statement?
Yes, sir.
The second box that's checked states that you're waiving your right to an appeal, which means you're giving up your right to an appeal. Do you understand that statement?
Yes.
Now, Mr. Cassell, before you signed and initialed all of these documents that I showed you, did you read the documents?
Yes, sir.
Did you understand what you read? Is
Yes.
everything in these documents true and correct to the best of your knowledge?
Yes, sir.
And Mr. Cassell, are you a citizen of the United States?
Yes, sir.
Say for states one.
Mr. Cassell, the state is offering State's Exhibit Number 1 to be used as evidence against you in your case. State's Exhibit Number 1 is the first document that I showed you on this tablet. And this is the same document that has your initials in these 2 different locations. And it has your signature on page 3. Is it all right for the state to use this document as evidence in your case?
Yes.
Okay, no objections. State's Exhibit Number 1 will be admitted. Mr. Cassell, is there any evidence that you are currently mentally incompetent to stand trial?
No, sir.
Mr. Cassell, I will accept your plea of no contest. I will find that you are mentally competent to stand trial. I will also find that your plea and waivers were freely and voluntarily given. And I will also find that there is sufficient evidence to find you guilty beyond a reasonable doubt. State, do we have a plea bargain agreement in this case?
We do, Your Honor.
And what is the agreement?
The agreement in this case is to 180 days probated over 15 months. The fine in this case will be waived and the defendant will be required to complete 100 community service hours. The interlock device, which has already been installed in his vehicle, shall be maintained for the duration of probation. And DWI standard conditions. And the defendant has 6 days jail credit, which will be credited towards the court costs.
Okay. Okay. Let's see. So, no fine. What is this court cost? Oh, okay. Now, Mr. Cassell, the state is offering that you serve 180 days in Jefferson County Jail, but you will not have to serve any time in the Jefferson County Jail because you'll be placed on probation for a period of 15 months. During the 15-month probationary period, you will not be required to pay a fine because the fine will be waived. You will be required to pay court costs of $392, a DWI fee of $100, probation fee of $60 a month, your analysis fee of $15 a month, reimbursement fee of $15. You'll also be required to pay Jefferson County DW Education and initial evaluation fee of $125 on the day of the police. Should a further evaluation be needed, you'll be required to pay an additional $50. Your total monthly installments, that is, the total amount that you will be required to pay each month while you're on probation is $117 a month. Will you be able to pay the $117 each month?
And that was with the credit days, Your Honor.
Oh, you know what? I didn't credit, yeah. So I gotta take 600 off of that. Okay, let me do this. So that'll be minus 600. That's gonna be less than that. Probably gonna be in the 90s. So that'll be 1132. Okay. Okay, so Mr. Let's say how the state is offering that you serve 180 days in Jefferson County Jail, you're given credit for the 15. You will be placed on probation for 15 months. During the 15-month probationary period, you're not required to pay a fine. You will be required to pay court costs of $392. You also, and you'll be credited. Now, the fine and court costs goes toward the $600 goes toward the fine and court costs. The fine and court costs is just $392. Okay, so it's not, it doesn't go toward the probation fees and the other fees. So actually, let me do this here again. If we zero out, we're gonna zero out the court costs. Okay. We're gonna zero out the court costs. $88,000. Okay, now, Mr. Let's say the state is offering that you serve 180 days in Jefferson County Jail. You will not be required to serve any time in Jefferson County Jail because you'll be placed on probation for a period of 15 months. During the 15-month probationary period, you will not be required to pay a fine. And the court cost in this case is $392, but you have 6 days credit toward that, so the fine will be zero. I mean, the court cost will be zero out. You'll be required to pay a $100 fee of DWI fee. You'll be required to pay a probation fee of $6 a month, your analysis fee of $15 a month, reimbursement for $15. Your total monthly installments is $88 a month. Will you be able to pay the $88 each month? You'll also be required to pay Jefferson County DW Education and initial evaluation fee of $125 on the day of the police. Should a further evaluation be needed, you'll be required to pay an additional $50. You'll be required to also perform $100 of community service. Install an interlock device on any vehicle that you want to operate, and I think the prosecutor stated that you already have that interlock on your vehicle.
Yes, sir. I had a question about that as well. I'm planning on getting a different vehicle and,
Well, you would have to discuss that with your probation officer.
okay,
They'll tell you what to do.
okay. Thank you.
You will also be required to attend a completed DW education class, have an alcohol assessment, adhere to the other standard terms and condition of probation. Mr. Cassell, do you understand the state's offering?
Yes,
Think the state's offer in your case is fair and just?
yes,
Do you accept the state's offer?
yes.
Now, Mr. Cassell, this will conclude this case. You're gonna stand next to the village, follow his directions. And once you finish following his directions, you're gonna come back before the court. Okay, well, he has to come back.
Second case.
Well, I'm gonna need this here copy. Cool. I'm gonna need him to sign I'm gonna need another judge's explanation. Because that other one went in the other case. You can just grab that one off the table, that's fine.
Thank you.
Well, you just gonna, that's the same document that you previously signed. I think in this one, you're applying for court appointed attorney, is that correct?
Yes,
To that, right, hold on. Mr. Pickens, could you give him that document for me? Here's the document. Right there. Okay, Mr. Cassell. I have before me. What is it? Pause number on this. That, the one for the family violence. I have before me two documents. The first document is titled Judge's Explanation of Rights of Defendants Without Attorney. You recognize this document? And is this your signature on the line that's titled Defendant?
yes,
Or are these your initials on the line that states you'd like to apply for court appointed attorney?
yes.
I also have another document that is titled Jefferson County Affidavit of Indigence. Do you recognize? Do you recognize this document?
Yes,
And is this your signature on the line that's titled defender signature?
yes, sir.
Before you signed and initialed these documents, did you read the documents?
Yes, sir.
Do you understand what you read?
Yes,
Is everything in these documents true and correct to the best of your knowledge?
yes, sir.
Mr. Casello, read your answers based on your answers to meet the eligibility requirements for the appointment of a court-appointed attorney. And the attorney that will be appointed to represent you is Attorney Nathan Reynolds. Attorney Reynolds will be given information to contact you, and you will also be given information to contact him by our court coordinator, but before she gives you that information, and the bailiff is gonna hand you some bond conditions. You can handle the document that is titled Standard Bond Conditions in County Code Law Number 2. I'm gonna go over these bond conditions with you.
Yes, sir.
And it states as follows: following return of criminal information in County Code Law Number 2, Jefferson County, Texas, all bail bonds executed for release within the defendant name herein are ordered subject to the additional conditions. Number 1, defendant shall commit no offense against the laws of this state, any other state, or of the United States. Do you understand that condition?
Yes, sir.
Condition number 2, the defendant shall submit to testing for drugs and alcohol at any time as directed by the court. The court may revoke the bond and order the arrest of any defendant who A, refuses to submit to a test for drugs and alcohol when directed to do so by the court, or B, submit to a test for drugs and alcohol, and the test indicates the presence of drugs and alcohol in the defendant's body. You understand that condition?
Yes, sir.
And condition number 3, the defendant shall not communicate either directly or indirectly with the alleged victim of the pending offense, and the defendant shall not go to any residence, school, or other location frequented by the alleged victim. You understand that condition?
Can we waive that condition?
That's up to, state, you, please come forward. Um, with regards to condition number 3. Now, let me ask you, so you said, is the person who's just talking, is that the
The
victim?
complaining witness, Your
The
Honor.
complaining
Yes.
witness?
And our office has spoken with the complaining witness previously. She has expressed to us her intent to see the defendant in this case, regardless of bond condition. So,
Well, okay, but do they live together or something?
I don't know that they live together.
No, we not talking about husband, y'all not a husband and wife, are you?
Engaged.
But- Well, I don't think I'm gonna waive this condition. Yeah,
You're at the court's mercy.
yeah, I'm not gonna waive that condition. That's a condition of your bond. As long as you're on this bond, that's a condition that you have to adhere to, okay?
So I leave here then, I mean,
Well, the defendant shall not communicate either directly or indirectly with the alleged victim. And the defendant shall not go in their residence, school, or other location frequented by the alleged victim. Okay? So that's not gonna be waived. All right, now do you understand that condition?
yes, sir.
Now, condition number 4 does not apply. Condition number 5 does apply. Condition number 5 states that defendant is prohibited from possessing a firearm or ammunition unless defendant is a peace officer as defined by section 1.07 of the Penal Code Act to be engaged in employment as a sworn full-time paid employee of a state agency or political subdivision. Do you understand that condition?
Yes, sir.
Now, if you violate any one of these conditions, your bond can be revoked. If your bond is revoked, the warrant be for your arrest, you'll be arrested and placed in the Jefferson County Jail. Do you understand?
Yes, sir.
All right. Your case is going to be reset. You're gonna get your reset from our court coordinator. Once you get your reset, you're free to go and you have a blessed day. Okay. Okay. Now, next case is Jamie D. Bell, cause number, what? Oh, so an attorney was hired?
Hold on one second, Judge.
Okay. And, Chase Grove, okay. Next two cases are cause numbers 25 CCCR 0154, cause number 25 CCCR 0155. Both cases are styled the state of Texas versus Chase Allen Grove. Chase Grove was scheduled to be in court this morning at 9 o'clock AM. At 9 AM, the court's really called the name of Chase Grove at the courthouse door. Chase Grove did not answer. Chase Grove has not appeared in court since the court has been in session. The time now is 11:44 AM on today's date of March 11 of 2025. Mr. Bailiff, would you please call the name of Chase Grove at the courthouse door? Chase Grove. Chase Grove. No response. Chase Grove's name was just called again at the courthouse door by the court's bailiff. Chase Grove did not answer. Reasonable time has passed to give Mr. Grove an opportunity to appear in court. State, do you have a motion?
State moves for bond forfeiture.
In each case, state, Chase Grove bond will be forfeited. In clause numbers 25 CCCR 0154 and clause number 25 CCCR 0155, and warrants shall be issued for his arrest. This will conclude the calling. Oh, we heard anything from Miss, it was reset?
No.
Jermaine Duhan,
He's in the back, Judge.
That's
So
the
went to
one.
Burbank.
Yeah, they said they said he was in the office, he left, they text, they called,
No response.
no response.
He has a pending felony.
And,
Yes,
and received misdemeanor.
Oh, yeah.
a new misdemeanor?
Yeah, it has not yet been filed.
Oh,
Then-
okay, well, it's gonna be reset anyway, okay. Just reset it, standard reset.
Okay, don't put it with the felony.
Well, you could, since it's coming up. You can put just, since it's April 1st.
Okay.
Okay, this will conclude the calling of the court's arraignment docket on today's date, March 11, 2025, in County Court at Law Number 2, Jefferson County, Texas. Judge Terrence Holmes presiding. Everyone, please have a blessed day. Prosecutors, you are excused. You are also excused. All right, y'all have a blessed day.